Patricia Ann Holloway had been a federal judge for 22 years. She had taken the oath at 32 years old. She had been the youngest black woman to receive a federal appointment in the district at that time. She had not thought about that record much after the day she was sworn in. She thought about the cases. She thought about the law. She thought about the people who came before her and what they deserved from the institution she represented. She spent 22 years thinking about those things. She retired at 54. Her mother, Clara, had worked as a domestic worker for 27 years. She had cleaned other people's houses. She had cooked other people's meals. She had watched other people's children on Tuesday afternoons when the regular arrangement fell through. She had done all of this with a precision and reliability that had built over those 27 years, a reputation for competence that traveled ahead of her. She did not need to introduce herself in that world. She arrived, and the people who had hired her knew from the first day that everything would be exactly as it should be. Her father, Robert, had been a postal worker. He drove the delivery route on the South Side for 30 years. He had worked 2 jobs for 3 of those years when Patricia was in high school. He had not told her about the second job until she was in law school. She had found out from her aunt. She had called him and said, "Why didn't you tell me?" He said, "Because it was not your job to know. It was your job to study." She said, "I would have worked." He said, "I know. That is why I did not tell you." She carried this with her for 30 years. She carried it into the courtroom and onto the bench. She carried it through every case in which a person came before her who had worked 2 jobs and not told their children and had still not been able to close the distance between where they were and where the system said they were supposed to arrive. She understood that kind of distance. She had been the beneficiary of people who had run hard to close it for her. She did not forget that. She had attended Caldwell University on a full academic scholarship. She had studied political science and history. She had been on the debate team. She had been the team captain in her junior year. She had also worked 15 hours a week in the university library. Not because she needed the money. Robert and Clara had made sure she did not need the money, because she believed in working. Because she had watched Clara and Robert work all of her life and understood that work was not a burden. Work was what connected you to the thing you were building. You were always building something. The work was how you built it. She had attended Georgetown Law on a federal fellowship. She had been one of 4 fellowship recipients that year. She was the only black woman. She had thought about this once and then set it aside. Her job was not to be the only. Her job was to do the work well enough that the category of only became irrelevant. She had been 22 years old when she thought this. She still believed it. She had seen enough courtrooms to know it was true. She had clerked for Judge Arthur Winslow in the federal district for 2 years. Judge Winslow was 73 years old. He had been on the bench for 31 years. He was precise and economical in his language. He had told her on the first day, "Your job as a clerk is to find the seam where the law and the facts do not align." He said the written opinion will say where they align. Your job is to find where they don't. That is where the hard work is. She had found many seams in 2 years. He had written some of them into his opinions. He had not always credited her. He had not needed to. She had learned what she needed to learn. She had then joined the U.S. Attorney's Office for 6 years. She had prosecuted fraud cases for 3 years and public corruption cases for 3. She had been good at both. She had also been increasingly aware in those 6 years that the system produced outcomes that had a relationship to the law, but were not always determined by it. Other factors entered, factors that did not belong in a courtroom, and that she could see from the prosecution side, but could not address from there. She thought she could address them from the bench. She applied for an appointment. She received it. She was 32 when she was sworn in. She knew she was the youngest black woman to receive that appointment in the district. She did not hold on to that fact. She held on to the work. In 22 years on the bench, she had presided over 412 cases. She knew the number. She kept a record. Not officially, the official records were in the court system, but she kept her own. in a journal at home, not the decisions. The human dimensions of the decisions, what it cost each party, what she had considered that did not appear in the written opinion, what she had done well, and what she would do differently if the law and the facts allowed. There was one entry from year 9 that she read every other year. It was about a case involving a 43-year-old man named Gerald Watts, who had been charged with a non-violent drug offense, and who had, by every account in the file, been attempting to rebuild a legitimate life when the charge was brought. The law was clear. The guidelines were clear. She had followed them. She had also written 3 pages in the journal that night about the inadequacy of the guidelines and what they failed to account for and what she would have done differently if she had written them. She had sent those 3 pages, condensed and formalized, to a subcommittee that was reviewing sentencing guidelines the following year. They had responded. The response had been polite and noncommittal. 2 years later, the guidelines had been revised. Not exactly as she had proposed, but the direction was the same. She did not know if her letter had contributed. She did not need to know. She had stated the record, clearly, on paper. That was the job. She had 31 journals on the shelf in her study on Carver Avenue. When she retired in January of the current year, she had written the last entry of the 31st journal on her last day on the bench. She had written about the case she had decided that morning, a contract dispute that had taken 14 months and had ultimately turned on a clause that the parties had both signed without fully reading. She had written the clause was in the document. It was there from the beginning. The document was available to both parties for the full 14 months. What is available and what is read are not always the same. That is the seam. That is where the work is. She had closed the journal. She had put it on the shelf. She had stood in her chambers for a long time. She had looked at the window. She had looked at the desk. She had looked at the chairs where attorneys and witnesses and defendants and plaintiffs had sat for 22 years and said things that required her full attention. She had given her full attention. She had given it every day. That was over. Now she was going to give it to students. The work would continue. The form would change. Then she had gone to teach. She taught 1 seminar per semester at Caldwell Law School, her undergraduate alma mater's new law program. The seminar was called Evidence and Credibility. It was for third-year students. She covered what the rules said and where they came from and what they were designed to protect. She also covered what the rules missed. What happened when a document was present but not read. What happened when a presumption preceded the evidence. What the cost of that was in specific documented cases. She wanted the students to understand both the law as written and the law as applied. The gap between those 2 things was where the work lived. She wanted them to be comfortable in that gap. She wanted them to know it was real and know how to navigate it. She wanted them to be the kind of attorneys who read every document before they made a presumption about what it said. She had taught the first session of the current semester 6 weeks before the flight. 14 students, all third year, all either at a clerkship or about to begin one, all smart. Not all of them had learned yet to read before they concluded. She had opened that first session with a case from year 11 on the bench. It was a landlord-tenant dispute. The lease had contained a clause on the 3rd page in the 2nd paragraph of the maintenance section that specified the tenant's obligation to provide written notice within 48 hours of any structural issue. The tenant had provided verbal notice. The landlord had documented the verbal notice in their own records but had not provided any written confirmation that the notice had been received. When the dispute came before her, both parties had records. Both records were accurate as far as they went. Neither record was complete. She had asked both attorneys, "Where is the written notice?" One said it was provided verbally. The other said it was never provided in writing. Both said it is in our records. She had said, "Show me the records." The records said what both parties had claimed. Neither record contained the other party's record. They were each correct about what was in their own file. They had each presumed that their file was the complete file. It was not. She used this case to explain to 14 third-year students what the difference was between what your file says and what the full record says. She said when you are in a dispute, the question is not whether your document is accurate. It usually is. The question is what your document does not contain. What is in another record that you have not read? What you are presuming about the record that you have not seen. She said the gap between what you know and what you presume you know is exactly where cases turn. If you do not know the gap is there, you will walk into it. If you know it is there, you can find it first. One of the students, a young man named James Okafor, who had grown up in the city and had clerked for a federal public defender the previous summer, had asked what happens when one party has access to the full record and the other party does not. Patricia had said that is the question. She said that is the question I want you to be asking at the end of every case you prepare. She said who has access to what? Who has read what? Who has presumed rather than verified? She said the person who reads the full record before they conclude is almost always in a better position than the person who concludes before they read. She said almost always is not the same as always, but it is close enough to build a practice on. She was flying home from the National Judicial Conference in Washington, D.C. She had attended for 15 consecutive years. She was no longer a sitting judge. She had been invited as a former jurist. She had presented a paper on evidentiary standards in the age of digital documentation. The paper had been well received. She was satisfied with the reception. She was also tired. She had been presenting and conversing for 3 days. She wanted to be home. She was booked in first class on Meridian Airlines Flight 2247. She was a Diamond Elite member. She had traveled this route Washington, D.C. to Riverside twice a year for 15 years. She had flown a total of 847,000 miles on Meridian Airlines. She had accumulated more miles than she used because she was not a person who maximized benefits. She used what she needed. She renewed what she was given. She was given Diamond Elite status every year automatically. Her seat was 2A. She had selected it 3 weeks before the flight. It was her preferred seat. Left side window, first row. She could see the wing from 2A, which she liked. She kept her carry-on in the overhead bin above 2A. She sat down. She put her reading glasses in her lap. She opened the folder with the conference materials she wanted to review on the flight. She was planning to work for the first hour and then rest. The flight was supposed to depart at 4:35. At 4:22, a gate agent came aboard. He was young, mid-20s. He had his airline uniform on the collar slightly too high, the lanyard with his badge showing his photograph and the name Kevin Strand. He came down the aisle from the jet bridge. He stopped at seat 2A. He said, "Ma'am, I need to see your boarding pass." Patricia looked up. She said, "Is there a problem?" He said, "There's a seating conflict. I need to see your boarding pass." She opened her bag. She had the boarding pass in the outer pocket. She always kept it in the outer pocket. She had been doing this since before boarding passes were printed on phones. She handed it to him. He looked at it. He looked at his tablet. He looked at the boarding pass again. He said, "I'm going to need you to wait here." She said, "This is seat 2A. The boarding pass says 2A. Is there an issue with the seat assignment?" He said, "There's a passenger who claims they were assigned this seat." She said, "I was assigned this seat 3 weeks ago. It is my preferred seat." She said, "My name is on that boarding pass. I am Patricia Holloway. I have 847,000 miles on this airline. I have been in this seat many times." He said, "I need to verify." He went back toward the jet bridge. She sat. She looked at the wing. She thought, "I have been here before. Not on this plane, in this moment, in this exact architecture of someone deciding before the evidence is reviewed what the outcome will be." She had seen it from the bench for 22 years. She had seen it in depositions. She had seen it in opening statements. She had seen it in how jurors looked at defendants before a single witness had spoken. She had written opinions about it. She had instructed jurors about it. Presumption is not evidence. What you expect to see is not what is there. What you expect cannot substitute for what the record actually says. She thought about Clara. She thought about Clara arriving at other people's houses and being exactly who she was without announcement and doing the work completely and leaving everything in order. She thought about Robert on the delivery route with 2 jobs in his pocket and saying it was not your job to know. She straightened her reading glasses. She picked up her conference folder. She went back to work. Kevin Strand came back at 4:28 with an airport security officer. The officer's name was Michael Connolly. He had been with airport security for 12 years. He was 44 years old. He was carrying a radio and a copy of the seat manifest that Strand had printed. Connolly looked at the manifest. He looked at the seat numbers. He looked at Patricia. He said, "Ma'am, can I see your boarding pass?" She handed it to him. He looked at it. He looked at the manifest. He looked at it again. He said quietly to Strand, "What's the conflict?" Strand said, "The passenger in 4C says he was assigned 2A. Connolly said, "Who is the passenger in 4C? Strand said, "Bradley Lester." Connolly said, "Where does it say 4C? Strand showed him the manifest. "Bradley Lester seat 4C. Patricia Holloway seat 2A. Connolly said she is in 2A. The manifest shows her in 2A. Where is the conflict?" Strand said Mr. Lester came to the gate and said he was supposed to be in 2A. He said he had been upgraded. Connolly said, "Does he have documentation of the upgrade?" Strand said he said the system had done it automatically. Connolly said, "Does the manifest show an upgrade?" Strand looked at the manifest. The manifest did not show an upgrade. He was quiet. Connolly looked at Patricia. He said, "Dr. Holloway, your seat is 2A. "I'm sorry for the interruption." Patricia said, "Thank you." Connolly turned to Strand. He said, "This is resolved." He started to leave. Strand said, "I still need to verify the claim." Connolly turned back. He said, "What claim?" He said, "The passenger in 4C does not have documentation of an upgrade. The manifest does not show an upgrade. The current seat holder has a boarding pass showing 2A, and she is sitting in 2A. What are you verifying?" Strand said, "Mr. Lester is a premium member." Connolly said, "So is Dr. Holloway. He is in 4C. She is in 2A. This is finished." Strand said, "I need to speak with Mr. Lester again." He went back to the jet bridge. Patricia watched him go. She looked at Connolly. She said, "How long has he been with the airline?" He said, "I don't know." He said, "Ma'am, you are in the right seat. I'm sorry." She said, "Thank you for reading the manifest." He nodded. He went back to the jet bridge. Patricia sat. She looked at the wing. She thought about how long the manifest had been on Strand's tablet before he had looked at it carefully. She thought about what had happened in the 4 minutes between her being asked for her boarding pass and Connolly arriving. Something had been decided in that time. Not with documentation, not with evidence, with a presumption. She had been on the federal bench long enough to know what presumptions cost. She had written enough opinions about what happens when process is short-circuited by assumption. The assumption had been wrong. The manifest was correct. The boarding pass was correct. The seat was hers. She picked up the conference folder. She went back to the Evidentiary standards paper. She made a small notation in the margin of page 14. The notation was about documentation, about what it means when a document is right there and a person chooses not to read it. She would use it in the seminar. During the 12 minutes between Connolly's departure and Vasquez's arrival, Patricia sat in 2A and did not move. She had told her conference materials. She had read 2 pages of the evidentiary paper. She had made 1 additional notation in the margin. She had thought about the case of Gerald Watts from year 9. She had thought about the clause that both parties had signed without reading. She had thought about what is available and what is actually read. She had thought about the manifest which had been on Strand's tablet from the moment he came aboard, which had contained every fact needed to resolve the situation in 6 seconds, which had not been read until Connolly prompted the reading. She had thought, "I am in a seating dispute on an airplane." She had also thought, "I have been in this architecture before. Not on an airplane, in a courtroom, in a hallway, in a parking lot, in a store. In any of the dozens of places where a black woman in her 50s encounters someone who has decided before the evidence is reviewed. She had thought the manifest is correct. The boarding pass is correct. The seat is mine. None of those facts are in dispute. The facts have always been clear. The question has never been whether the facts are clear. The question has been whether anyone will read them. She had thought about Clara. She had thought about Clara arriving at other people's houses and being exactly who she was and doing the work and leaving everything in order and never once having her presence in that house confirmed by anyone. She just was there. She did the work. The work said she was there. That was the whole record. Patricia thought the seat says, "I am here." The boarding pass says, "I am here." The manifest says, "I am here." I am here. That does not require Strand's confirmation. It does not require Lester's acquiescence. It does not even require Vasquez's announcement, though the announcement is welcome. The record was correct before the announcement. The announcement will state what was already true. That is all announcements ever do. State what is already true. That is the job. She turned a page. She continued reading. Those 12 minutes were not the longest 12 minutes she had waited. She had waited longer in depositions when the attorney across the table was looking for a document they had misfiled. She had waited longer in chambers when a jury sent a question at 4 in the afternoon and she needed to draft a response that was legally accurate without being directive. She had waited through 22 years of deliberation periods, some of which stretched 3 and 4 days, knowing that the record she had built was correct and that her job was to be exactly present when the deliberation ended. Waiting was not the problem. She knew how to wait. The problem, if it was a problem, was the waste. She had been in enough proceedings to know that a document reviewed early prevents 3 documents drafted late. Strand had had the manifest before he came down the aisle. He had the manifest on his tablet. She had seen it in his hand when he first stopped at 2A. He had looked at her before he looked at the tablet. That was the sequence. She had watched the sequence closely. She had been watching sequences like that for a long time. She thought about a case from year 6 on the bench. A man had been charged with a violation that hinged on whether he had been notified of a hearing date. The notification had been sent. She could see that in the record. It had been sent to an address the man had moved away from 2 years earlier. The court's file showed the new address. The notification had gone to the old one. Someone had looked at the file and then looked at an older record that predated the address change and had used that one. They had not compared the 2 records. They had used the first record they found. The man had not known about the hearing. The case had proceeded without him. It had taken 14 months to untangle. She had written 7 pages in her journal about that case. She had written the record was there. The new record was right there in the file, filed 3 weeks after the address change, signed by 3 parties. What was missing was not the record. What was missing was the habit of reading it completely before concluding. She thought, I am having a live demonstration of my seminar material. She also thought, this is not an abstraction. This is my seat. This is my flight. This is my boarding pass, and my name, and my 847,000 miles and 22 years of decisions made on complete records. The demonstration is accurate. It is also inconvenient. She turned another page of the evidentiary paper. She made a second notation. Captain Elena Vasquez had been with Meridian Airlines for 15 years. She had 9,200 hours in the cockpit. She was 51 years old. She had earned her first flight hours at 22 and had been flying commercially since 28. She had logged time on 4 different aircraft types. She had never had an incident of any kind in the cockpit. She ran a precise operation. She expected the same of her crew. She also had a particular history with seating disputes. In year 4 with Meridian, she had been a passenger on another carrier traveling on her day off, and had been asked to move from a seat she had paid for because the gate agent believed there had been a system error. There had been no system error. She had been asked to move because the passenger who claimed her seat was louder and more insistent. She had not moved. She had asked the gate agent to show her the manifest. The gate agent had shown her the manifest. Her name was on the seat. The other passenger's name was on a different seat. The gate agent had apologized. She had stayed in her seat. She had thought about that flight many times in 15 years. She had thought about what it meant to be the person who knows the record is correct and still has to wait for someone else to read it. She had thought about the 12 minutes she had waited. She had thought, I will not create a situation in which a passenger on my aircraft waits 12 minutes for someone to read a document that was available at the start. She had come out of the cockpit when she heard the raised voices. She had heard something specific in the tone, not volume, not anger. The particular sound of a situation in which a process is failing. She had heard that sound before. She recognized it. She walked to the front of the first-class cabin. She looked at the situation. She looked at Strand standing in the aisle. She looked at Patricia in seat 2A. She said, "What is the situation?" Strand explained. She listened. She did not interrupt. She took his tablet when he offered it. She looked at the manifest. She looked at it for approximately 6 seconds. She looked at Patricia's seat number. She looked at Bradley Lester's seat number. She handed the tablet back. She said Dr. Holloway is in seat 2A. She said Mr. Lester is in seat 4C. She said this is resolved. She looked at Strand. She said, "Please exit the aircraft. We are 22 minutes delayed." Strand said, "I need to verify with Mr. Lester." Vasquez said, "I have reviewed the manifest." She said the manifest is the verification. She said, "Please exit now." He went. Vasquez turned to Patricia. She said, "Dr. Holloway, I am Captain Elena Vasquez. I am sorry for this. You are in the correct seat. I apologize on behalf of the airline." Patricia said, "Thank you, Captain." Vasquez said, "I would like to make an announcement." Patricia said, "That is your decision." Vasquez nodded. She went to the interphone at the front of the cabin. She pressed the button. Her voice came through the cabin speakers clearly. She said, "Ladies and gentlemen, I am Captain Vasquez. On behalf of Meridian Airlines, I want to apologize for our 22-minute delay. We experienced a seating dispute that has now been fully resolved. Our manifest is correct. The passenger in seat 2A is exactly where she is supposed to be." She said, "I want to personally and publicly apologize to our passenger, Dr. Patricia Ann Holloway, for the inconvenience and the delay." She said, "Dr. Holloway, thank you for your patience." She said, "We will begin our departure sequence now." The cabin was quiet for a moment. Then a woman in row 3 began to applaud. Then the rest of the first-class cabin. Then the business-class passengers who had heard the announcement. Then someone in economy who apparently understood the situation and decided to join. Patricia looked out the window at the wing. She did not turn around. She let the applause be what it was. She looked at the wing. She thought about Clara. She thought Clara never got to sit in 2A. She thought Clara made it possible for me to be the person who is in 2A. She thought the least I can do is sit here with my full name, said out loud into the cabin, and know that this is where I belong, and that knowing it does not require anyone else to confirm it. But the confirmation was good. It was accurate, and accuracy mattered. That was what 22 years on the bench had taught her. When the record is correct, say so. When it is not, say so. The record stated clearly for everyone to hear. She had been on the bench long enough to know the difference between what was said and what was meant. Vasquez had said Dr. Patricia Ann Holloway. She had meant this is a person of standing, and we see her, and we are saying so. The cabin had heard both things. The record had been corrected in the most public way available in this particular room. That was sufficient. That was actually more than sufficient. After the announcement, the cabin settled. The applause had lasted about 30 seconds. Patricia had looked out the window at the wing. She had heard the applause begin and continue and end. She had not turned around. She had thought the cabin heard it. The cabin heard her name. That is the record stated for a room full of witnesses. That was sufficient. Bradley Lester had at some point during the applause moved to seat 4C. She did not know exactly when. She had not been watching. The first-class flight attendant, a woman named Sophia, who had been standing near the galley throughout the incident with the specific composed expression of someone who has been trained to de-escalate and is waiting for the moment when de-escalation is no longer necessary, came to Patricia with a glass of water. She said, "I'm very sorry for what happened." Patricia said, "Thank you." She said Captain Vasquez handled it well. Sophia said she usually does. Patricia said, "Good." The flight was 22 minutes late departing. It was 4 minutes early arriving. The weather over the mountain corridor had been clear. The tailwind had been useful. Patricia had read for an hour and slept for 40 minutes. She had eaten the meal that was served in the first hour. It was a reasonable meal. She did not usually eat airline food, but she had been at the conference for 3 days, and she was hungry. The woman in row 3. Her name was Angela Morse. She was 31 years old, a licensed clinical social worker who worked in family services in the city and was traveling to a regional conference on trauma-informed care, had filmed part of the exchange between Strand and Connolly on her phone. She had started filming when Connolly came aboard. She had not known exactly why. She had said later to the small circle of colleagues she described it to, "I have been in enough situations where the thing that happened and the thing that was documented were different. I wanted there to be a document." She had filmed for about 90 seconds. She had captured Connolly reading the manifest. She had captured him saying she is in 2A. The manifest shows her in 2A. Where is the conflict? She had captured Strand saying, "I still need to verify with Mr. Lester." She had captured Connolly's expression when Strand said that. She had put the phone away when Vasquez arrived. She had put the phone away because she had decided that the announcement needed to be received and not recorded. Some things you receive. She received it. She posted the video that evening after she landed. She had 14,000 followers. She wrote, "This is what happened on my flight today." She wrote the gate agent spent 15 minutes trying not to read a manifest that resolved the situation in 6 seconds. She wrote the captain came out of the cockpit and fixed it. She wrote that is what right looks like. In 48 hours, the video had been viewed 211,000 times. Someone at a national news organization had seen it. They had tagged Meridian Airlines. They had also tagged the airport security service. They had asked for a comment. Meridian Airlines had responded within 4 hours. They had said, "We are aware of the incident and have launched an internal review." The security service had said nothing. Michael Connolly had not been the subject of the complaint. He had read the manifest. He had stated what it said. He had done his job. Patricia landed in Riverside at 7:44. She went home. She walked in, put her bag by the door, took off her shoes, and sat in the chair by the window in her study for 15 minutes. She looked at the journals on the shelf. 31 journals, 22 years of cases. She thought there will not be a 32nd journal, but there is a seminar, and there are students, and there are things to say to them that could not have been said before this evening. She picked up her phone. She called her mother. Clara Holloway was 79 years old. She lived in the house on Maplewood Drive where Patricia had grown up. The house still had the dining room table that Robert had brought home in 1972 when Patricia was 2. He had found it at an estate sale. He had refinished it himself over 3 weekends. Clara served every meal at that table. She still did. Clara was sharp and precise and had opinions about most things that she stated directly. She had been that way for as long as Patricia could remember. She had also been, for as long as Patricia could remember, a person who listened completely before she spoke. She did not respond to the middle of a story. She waited for the end. She had learned this, she told Patricia once, from waiting tables in the summer of 1963 to pay for nursing school. She had said, "You cannot bring the right dish if you leave before the order is finished." She had waited tables for 2 summers. She had not finished nursing school because Robert came along and circumstances changed. She had started working as a domestic worker instead. She had done so with the same precision she brought to every table she had ever served. She answered on the 3rd ring. Patricia told her what had happened. Clara was quiet while she listened. Patricia told her about Strand. She told her about the manifest. She told her about Connolly reading it in 6 seconds. She told her about Vasquez. She told her about the announcement. She told her she said my full name, out loud, into the speakers. Dr. Patricia Ann Holloway. Clara was quiet for a moment. Then she said, "Good." "That's right." She said, "Did you get on with your reading?" Patricia said, "I got about 40 minutes in before we boarded." Clara said, "Well." Patricia said, "I know." Clara said, "You have always done what you were going to do regardless of what was happening around you." She said, "You got that from your father." She said, "I hope you thanked the pilot." Patricia said, "I did." Clara said, "Good." Patricia filed a formal complaint with the airline on Friday morning. She sat at the desk in her study on Carver Avenue at 7:15 a.m. with her coffee and her legal pad, and she wrote it the way she had written every motion summary and every bench memorandum for 22 years. She began with the facts in chronological order. She stated each fact with its timestamp. She stated what document had been available at each point and whether it had been reviewed by the relevant party. She stated the outcome. She stated what she expected as a response. She did not editorialize. She did not say what she believed had motivated the gate agent's initial decision. She stated the observable facts and their sequence. The observable facts were sufficient. They had always been sufficient. The problem had never been the absence of evidence. The problem had been the refusal to read the evidence. She noted that. She noted it in the precise language she would have used in a written opinion. She noted the manifest was available to the gate agent prior to escalation. The manifest reviewed would have resolved the dispute without involvement of airport security. The manifest was reviewed only after a security officer prompted the review. She submitted the complaint at 8:07. She poured a second cup of coffee. She opened the evidentiary paper she had annotated on the flight. She had been writing formal documents since she was 27 years old. She had written them for judges and for opposing counsel and for the record and for panels and for subcommittees. She had written them in the U.S. Attorney's Office when she believed a case could be built and when she believed it could not. She had written them on the bench when the law required a written opinion and when it did not, but the case demanded one anyway. She had learned from Judge Arthur Winslow that the purpose of a written document was not advocacy. The purpose was precision. You said exactly what happened in the order it happened with reference to the evidence available at each point. You did not say what you felt about it. You did not say what you believed the other party's motivation had been. You said what was observable, what was documented, what was in the record at each moment. Judge Winslow had told her emotion is information, but it is not evidence. State the evidence. If the evidence is clear enough, the emotion is implicit. You do not need to name it. She had followed this principle for 27 years. She followed it now. She did not say the gate agent was biased. She did not say the decision was made based on something other than documentation. She said at 4:22 p.m. the gate agent approached seat 2A with a tablet containing the seat manifest. She said the manifest had not been reviewed before the approach. She said the passenger in seat 2A provided a boarding pass confirming her assignment. She said the gate agent did not compare the boarding pass to the manifest at this time. She said the gate agent requested verification from airport security. She said the airport security officer reviewed the manifest and found the boarding pass to be consistent with the manifest record. She said the gate agent continued to seek further verification after the manifest review was complete. She noted the information required to resolve the situation was contained in the manifest from the point of boarding. The manifest review took approximately 6 seconds in each instance it was conducted. The total time between initial approach and resolution by the captain was 22 minutes. She did not need to say anything more than that. The sequence spoke. The timeline spoke. The 6 seconds versus 22 minutes spoke. That was the whole argument. She did not need to make it explicitly. She had stated the record. The record made it. She submitted the complaint at 8:07. She poured a second cup of coffee. She opened the evidentiary paper she had annotated on the flight. The airline responded within 48 hours. The vice president of customer relations called personally. Her name was Sandra C. She had been with the airline for 14 years. She had read the complaint twice before calling. She said, "Dr. Holloway, I have reviewed the full record of the incident, including the gate agent's report, the security officer's report, and the cabin crew's account. I want to tell you that what happened was wrong, and that the record says it was wrong, and that we are going to say so clearly." Patricia said, "I appreciate that." She said, "What I would like to know is what changes." Sandra C. said the gate agent has been removed from customer-facing duties pending a full retraining protocol. She said, "I am sending you a written apology from the airline and from our CEO." She said, "I want to ask, is there anything further you would like from us?" Patricia said, "I would like to know what the retraining covers." Sandra C. said, "I will send you the protocol." Patricia said, "Thank you." The retraining protocol arrived on Tuesday. It was thorough. Patricia read it the way she read everything completely from the beginning before she formed a conclusion about it. She made notes on a separate legal pad. She did not write on the document itself. She had learned this from Judge Winslow, who had said, "Write on your notes, not on the evidence. You may need to show the evidence exactly as it arrived." She read the protocol twice. The first time to understand the overall structure. The second time to identify where the language did not match the intent. She marked 2 points where she thought the language could be clearer. The first was in the section on documentation. The protocol said the gate agent should review available passenger information before escalating a seating dispute. She noted available is imprecise. The word you want is provided. The manifest is provided at boarding. Available implies the document is somewhere and might be found. Provided means it is in the agent's hand. She said, "Write provided. It is more accurate. It removes ambiguity about what the agent is supposed to read." The second point was in the escalation section. She noted escalation to security should occur only after manifest review, not before or concurrent with it. The sequence matters. If the sequence is not specified, agents will decide the sequence themselves. She sent her notes back to Sandra C. Sandra C. wrote, "We will revise." They revised. Kevin Strand completed the retraining. He was 24 years old. He had been with the airline for 3 months. He was returned to customer-facing duties after 6 weeks. He had also been required to write a formal acknowledgement of what the manifest had shown and what he had failed to read before he chose to escalate the situation. That acknowledgement was in his file. It was in his... Bradley Lester had been moved to 4C without incident after Strand's departure. He had said nothing further about 2A. He landed in Riverside without incident. He had not been part of the formal complaint. His name appeared in the incident report as the source of the original disputed claim. Angela Morse's video had not named anyone. It had shown the interaction between Strand and Connolly in the aisle. It had captured Connolly's words, "She is in 2A. The manifest shows her in 2A. Where is the conflict?" It had cut before Vasquez arrived. Angela had not filmed the announcement. She had said in her post, "I did not film the announcement because I was listening to it." You film some things. Others you just receive. The journalist who covered the story, a woman named Rachel Kim, who had covered the federal courts for 11 years and had written about Patricia's work on the bench many times, called Patricia on Thursday. Patricia gave her 20 minutes. She said, "I have been on the federal bench for 22 years. I know what process is supposed to look like. I know what happens when process is short-circuited by something that is not evidence." She said what happened on that plane was a manifestation of something that does not belong on a manifest. She said the manifest was correct. The boarding pass was correct. The seat was mine. She said when the captain read my name into the speakers, she was doing what I have done in every written opinion for 22 years. She was stating the record. Clearly, for everyone to hear. She said that is what is supposed to happen. Rachel Kim used that quote as her opening paragraph. Patricia had given her 20 minutes and Rachel had used all of them. She was a careful journalist. She asked specific questions. She did not ask for Patricia's feelings about the incident. She asked for the sequence. She asked what was on the tablet when you first saw it. Patricia said the manifest. Rachel said, and did the gate agent read it before approaching you? Patricia said, not to my knowledge. He looked at me and then at the seat. Rachel said, and when did the manifest first get read carefully? Patricia said, when the security officer arrived. He read it in approximately 6 seconds. The information needed to resolve the situation had been on the tablet from the beginning. Rachel said, and the captain. Patricia said she read it when she came out of the cockpit. It took her approximately the same amount of time. Rachel said 6 seconds. Patricia said approximately. She said it is not a long document. It says who is in which seat. That is the information. It was always the information. Rachel had asked one more question at the end. She had asked, what would you want someone to take from this? Patricia had said I would want them to understand that the document does not change based on who reads it. It says what it says before anyone looks at it, and it says the same thing after. The question is whether anyone will look. She said a boarding pass is a simple document. A medical record is more complex. A lease agreement is more complex. A case file is far more complex. But the principle is the same. She said, read the document before you conclude about what it says. She said the record is not waiting for anyone's permission to be correct. It is correct. The only question is whether you will read it. The article ran on Sunday. It was picked up by 14 news organizations in 3 days. Patricia did not read all of them. She read Rachel's piece twice. She sent it to Clara. Clara called her on Sunday afternoon. She said I read it. Patricia said, and. Clara said she got the timeline right. Patricia said she is a good journalist. She works from the record. Clara said, like someone else I know. Patricia said I learned it from watching people who did the work and kept the record. Clara was quiet for a moment. She said, you're talking about your father. Patricia said, I am talking about both of you. Clara was quiet for a longer moment after that. Patricia waited. She had learned to wait for Clara. Clara did not speak before she was finished thinking. Clara said, I want to tell you something I have not told you. She said, when you were appointed to the bench in 1994, I went to the hardware store on Compton Street. Patricia said you did. Clara said I went there because I had a plan. She said I was going to paint the front steps of the house on Maplewood Drive. Patricia said you did not mention this. Clara said no. She said I stood in the hardware store for about 20 minutes looking at paint colors. She said I had never bought paint before. Your father always did the painting. She said I picked a color and I carried the can home and I opened it in the kitchen and I looked at it. She said I did not paint the steps. Patricia said, what did you do? Clara said I put the lid back on. She said I put it in the closet in the back bedroom. She said it has been there since 1994. She said I'm telling you this because I have not been able to explain it before and I think I can now. She said when you were sworn in, I felt something that I did not know how to account for. I had worked in other people's houses for 27 years. I had learned to be in rooms that were not mine and do work that would not have my name on it. That was the life, and I built it well, and I do not regret it. But when I heard your name, your full name said out loud in that courtroom the day you were sworn in, something moved. She said I went to the hardware store because I needed to do something with my hands, because I did not know what to do with what I was feeling. She said I could not figure out how to paint steps that were already clean. Patricia was quiet. Clara said that Captain said your full name. Patricia said she did. Clara said into the speakers where everyone could hear it. Patricia said yes. Clara said good. She said good. She said that's 30 years I have been waiting for someone to say it like that in a room where everyone was listening. Patricia said Mama. Clara said I know. She said go to sleep. You have a seminar Monday. Clara said, are you going to teach this in the seminar? Patricia said I'm going to use the evidentiary angle. She said the presumption that precedes the evidence. She said what it costs when you decide before you read the document. Clara said, and what it costs when someone reads it correctly. Patricia said yes. Both things. The cost of not reading it and what is recovered when someone does. She had been sitting in seat 2A. She had been sitting there for 7 minutes before Strand arrived. She had been doing what she always did on the first hour of a flight, working with her reading glasses on and her conference materials in her hands. She had been doing the work she had always done. The work did not stop because someone presumed a thing that the manifest did not say. The work continued. The manifest had always said what it said. Captain Vasquez had read it and said it out loud. Dr. Patricia Ann Holloway, seat 2A, where she is supposed to be. That was the record. It had been the record since she selected the seat 3 weeks before the flight. It had been the record before Strand came down the aisle. It had been the record while he failed to read it. It remained the record after Vasquez stated it clearly into the cabin speakers. Records do not change because someone looks away from them. They stay. They wait. They are there when the person who can read them arrives. She thought about her father's delivery route. Robert had driven the South Side for 30 years. He had known every address on the route. He had known which houses received packages regularly and which received only letters. He had known, without being told, which households were elderly and which were young and which had recently changed residence. He had not been asked to know these things. He had learned them because he was on the route every day, and he paid attention to what was in front of him. He had delivered to addresses that some carriers skipped because the approach was inconvenient. He had never skipped one. He had said when Patricia was 9 years old, if the address is on the route, it gets the delivery. That is the whole job. She had not thought about this for many years. She thought about it now in seat 2A, with the wing outside the window and the cabin settled and the manifest still on whatever screen Strand had been using when he left the plane. The manifest had said what it said. She was in the seat it said she was in. The delivery had been made. Robert had made deliveries that no one tracked to addresses. No one celebrated on a route that was the same every day for 30 years. He had made all of them. He had not needed acknowledgement for any particular one. The route was complete or it was not. He made it complete. He made it. Patricia thought, I am in this seat and this seat has my name on it and I have always been here and I will be here when this flight lands. That is the whole thing. The rest is commentary. She looked out at the wing. She heard Vasquez on the interphone. She heard her own full name in the cabin speakers. She looked at the wing. She did not turn around. She let the record be stated. She let the cabin hear it. She thought Robert drove the route for 30 years and Clara kept every house in order for 27 years. And they built something with that. And what they built was this, a woman in seat 2A who knows exactly what is in the manifest and is not going anywhere. She thought that is what they made with all of that work. She thought the least she could do was receive the acknowledgement without turning away from it. The acknowledgement was accurate. Accuracy deserved reception. Patricia went back to the seminar on Monday. She walked in with her folder and her reading glasses and the evidence paper she had annotated on the flight. She put the folder on the table. She looked at her third-year students. She said, I want to begin today with a question. She said, what is the difference between a presumption and a finding? She said, take 2 minutes. Think about it. Write 1 sentence. They wrote. She waited. She thought about the cabin. She thought about the silence before the applause. She thought about Vasquez's voice in the speakers. She thought about Clara saying that's right. She thought about the manifest. She thought about the moment when someone finally reads what the document actually says. She waited. She looked at the 14 sheets of paper on the table in front of 14 students who were 1 year away from beginning the work she had spent 22 years doing. She thought about what she wanted them to carry. Not just the rule, not just the procedural framework. The thing underneath the procedure. The reason the procedure exists. One student, a woman named Marlene Ochterberg, who had grown up in the southeast of the state and had worked for 4 years between college and law school as a paralegal, read her sentence aloud. She said a presumption is what you expect to find. A finding is what the record actually says. Patricia said, "Good." She said, "Now, tell me what happens in the space between those two things." Marlene said, "You can be wrong." Patricia said, "Yes." She said, "And who pays when you are wrong?" Marlene was quiet for a moment. She said, "Usually the person who is the subject of the presumption." Patricia said, "Yes." She said, "Almost always." She said, "And who benefits when you get it right?" Marlene said, "The record." Patricia said, "Yes." She said, "The record and the person the record belongs to." James Okafor raised his hand. He said, "You had this experience." It was a statement, not a question. Patricia said, "Yes." He said, "What was the cost of the presumption in your case?" She said, 22 minutes of delay. She said, "Inconvenience." She said, "A situation in which I had to sit in a seat that was mine and wait for someone to read a document that confirmed it was mine." She said, "In my case, the cost was modest." She said, "I want you to think about the cases where the cost is not modest." She said, "Where the document is a medical file and the presumption is about a patient's pain tolerance." She said, "Where the document is a lease and the presumption is about who belongs in the building." She said, "Where the document is a case file and the presumption has already determined the outcome before the file is opened." She said, "I am going to tell you something that I wrote in my journal on year 1 on the bench and have believed every year since." She said, "The most dangerous moment in any proceeding is not when the evidence is unclear. The evidence is usually clear enough. The most dangerous moment is when someone decides before they have read the full record that they already know what it says. That is the moment where harm enters. Not because the record changed, but because someone stopped reading it." The room was quiet. She let it be quiet. She had been a judge for 22 years. She had been a law school seminar instructor for 1 semester. She had spent 22 years building opinions from records. She would spend the next years teaching others to do it. The form had changed. The work had not. She thought about the day she had closed the 31st journal in her chambers. She had looked at the desk and the chairs and the window. She had given it her full attention. Now the desk was a seminar table and the chairs held students and the window showed a different view. The attention was the same. The demand of the record was the same. You read it completely, you state what it says, you do not conclude before you have read. And when you find the record and read it and it says what it says, you say so. Clearly. For everyone to hear. She said, "We will pick up on Thursday with the 3 cases I assigned last week. I want the full sequence for each, what was available, what was read, what was presumed, and what the outcome cost. Bring the documents. We are going to read them together." She picked up her folder. She put her reading glasses in her bag. She walked out of the seminar room and down the hall. In the parking lot, she paused for a moment. It was a clear morning. She thought about her mother standing in the hardware store on Compton Street in 1994 with a can of paint she had never opened. She thought about Robert finishing the delivery route for the 33rd consecutive year without skipping an address. She thought about Vasquez's voice in the speakers. She thought about the manifest. She thought about the fact that the manifest had said her name from the moment it was printed. Before Strand came down the aisle, before the applause, before Vasquez made the announcement. The name had always been there. Dr. Patricia Ann Holloway, Seat 2A, present and accounted for. She got in her car. She drove home. She sat at the desk in her study on Carver Avenue. She opened the notepad. She started the outline for Thursday's session. The record was right there. It was always right there. That was the work to read it, all of it, every time. Subscribe our channel. We find the record and we read what it says.